repeatedly yelling anti-Muslim slurs at a Muslim neighbor, taunting and threatening a neighbor with a mental disability, making persistent anti-LGBTQ comments to a gay neighbor, telling a neighbor of Asian descent to go home or that they aren't welcome in the neighborhood. These are examples of neighbor-on-neighbor harassment that could violate the Fair Housing Act. Everyone should feel comfortable and safe in their homes and neighborhoods, and it's important to understand rights under the Fair Housing Act to stop housing discrimination, harassment, and retaliation. The Fair Housing Act is a federal law that prohibits discrimination in housing based on race, color, sex, religion, national origin, disability, and familial status. These are considered protected classes. The Fair Housing Act also prohibits harassment based on protected class and retaliation based on exercising your rights or making a complaint. When we think of housing discrimination, we might typically think of situations like a landlord refusing to rent to someone because of their disability or race, or a seller attempting to limit home buyers to people of just one religious faith. But across Idaho, another type of housing discrimination is on the rise: neighbor-on-neighbor harassment. Harassing, threatening, or intimidating a neighbor violates the Fair Housing Act if it is severe or pervasive and based on a person's protected class. Neighbor-on-neighbor harassment might look like someone repeatedly yelling racial epithets, making threatening statements to someone based on their gender identity, or placing flyers around a neighborhood with threats directed at someone because of their race or religion. The harassing person can be in violation of the Fair Housing Act even if they aren't engaged in housing-related business. And landlords or managers may be liable for harassment that is taking place at their rental property if A, it is committed by an employee, or B, they know about it or should have known about it and took no action to stop it. The U.S. Department of Housing and Urban Development, or HUD, offers some recommendations for landlords and managers to help stop this type of harassment. 1. Establish and enforce anti-harassment policies. 2. Provide multiple ways for tenants to safely report problems. And 3. Take measures to ensure that reports of harassment are investigated and properly addressed. Each of us has a duty to ensure we are not engaging in behaviors that make someone feel scared or unwelcome in their home simply because of their protected class. If you feel you have faced harassment impacting the use and enjoyment of your home, you can file a complaint. Just visit the HUD website or call 1-800-669-9777 or 1-800-877-8339 for TTY. Retaliation for filing a complaint is a natural concern. Refusing to renew a tenant's lease or raising their rent just because they filed a complaint is illegal under the Fair Housing Act. Other examples may include threatening a tenant with eviction because they requested a reasonable accommodation related to their disability, or firing an employee because they cooperated with a HUD investigation. If you are a tenant, protect yourself from retaliation by making complaints or requests in writing, and be sure to keep copies for your records. Retaliation complaints can be made at the HUD website, hud.gov/fairhousing, or by calling the number on your screen. If you are a housing provider, make sure you have adopted policies against retaliation and that you educate your employees on those policies. Fair housing training on preventing retaliation is available, and ensure tenants have a way to report Fair Housing Act discrimination and that they are protected from retaliation after making a report. If you are an Idaho resident and have fair housing questions, you can speak to an attorney for free by calling Idaho Legal Aid at 208-746-7541. For more information about the Fair Housing Act, visit hud.gov or idaholegalaid.org.